G'day, g'day, and how you going? What do you know? I've forgotten the words. I hope you're doing really well. Thank you for joining me. My name is Joanne. I'm the Learner Lawyer. Down here, I've put some ways that you can help support the channel. Just hitting like and subscribe does it as well. I know that. I know it seems like I'm really high on caffeine. No, I'm doing really good. I'm doing really good. So I titled this, Braz's lawyer says he's not on bail. So what's going on? And then I've got an open chat. So there's a link. I'll repost the link if you want to join. And we talk about anything. We can talk about anything. I just thought, hey, I miss you all. We're going to get onto it's going to be a bit of a bumpy ride. We're going to look through the New South Wales Crimes Act. We're going to look through the New South Wales Crimes Act. We're going to try and sort out what's going on. I have spent a couple of hours this afternoon trying to work out what could have happened for Barilaro. What I'm thinking is that he's actually on bail, but he's got no bail conditions. That's what I'm interpreting, because I haven't been able to find anything to that. We want to look at the crimes that he's been alleged, what the penalties are. Then we're going to look at so that's the New South Wales Crimes Act. We're going to look at the Victorian Crimes Act, which I'm more familiar with. And when you start going through the Crimes Act, the New South Wales Crimes Act goes back to Federation 1900. And so there are some really, really, really interesting crimes in there that have since been repealed, of course, because some of those don't matter. But for example, they've repealed the conviction for sleepwalking. Yes, it was a crime at one point in time to be a sleepwalker. So it's really interesting to see what's been changed, what was there. The other interesting thing is that in the Victorian, so where I live in Victoria, there is a defence of marital coercion. Now, here is where it gets really, really interesting, because marital coercion, you actually have to be married. So if you're de facto, you can't use it. It's against a wife who's been coerced by her husband to commit a crime, okay? There's two problems, because it specifically says wife and husband. So if you're de facto, you can't use the defence. If you're same-sex, you can't use the defence, even if you are married. So this is a law that we discovered when we were going through our criminal, that I've gone through as I've gone through my criminal classes, to go, hang on a minute, this one needs to be updated. Because we know that coercion can happen regardless. But anyway, yeah, so, and I haven't gone through all the other states, but I'm sure if we went through other states, we will discover there's these really weird laws as well. Hello, Cal, how are you? See, I tried to give notice today. So let's look at hello, Vedandra. So let's look at what got me on this little bit of a rabbit hole today. And I started reading Crime Acts. Was this Danny Eade lawyers. So Danny Eade is the lawyer that is representing Barilaro. For the benefit of those who've incorrectly reported that Mr. Barilaro is on bail, please note that the police and the court have never, ever imposed bail conditions. There are no conditions of a bail that apply to Mr. Barilaro. Now, in my opinion, that's a contradictory statement, because it says who incorrectly reported that Mr. Barilaro is on bail. Okay, so he's saying he's not on bail. Please note that the police and the court have never imposed bail conditions. There are no conditions of bail that apply to Mr. Barilaro. Now, they're two different things. Bail and bail conditions are two different things. You can be on bail and have no conditions. So you can be on bail and have no conditions in New South Wales. So here we go. Welcome to my rabbit hole. So charging. So he was charged by, if police decide to formally charge you with an offence, they'll perform a formal charge at the police station, read it out to you. You do not have to say anything at this time, but you'll likely be, but anything you do may be recorded and used as evidence. It's best not to comment. Once you've been charged, you have a right to apply for bail. Now, this is New South Wales, okay? And I've gone through the criminal. They have so it says bail is simply an agreement to appear in court to face charge. It means at liberty, often with some condition, as opposed to being held in custody before the hearing of criminal charge. So, for example, bail is regulated in New South Wales and Victoria by their respective bail acts. Okay, and of course, bail's just changed in Victoria and New South Wales. So it is likely that he is out on bail with no conditions. Okay, so as I said, those two statements, I'm not sure. I think it is my opinion, they contradict each other. So let's see. So I did one report today. So there's been a little bit more. The Guardian actually listed what the charges were, which was interesting because then I went to the Crime Act. So so I need to just find the piece of paper I was working on. I had a piece of paper here because I'm going to write it down. And as I said, I've been going through, and I have to say, I have a lot of sympathy for law enforcement. So we're not lying down on this one. John Barilaro to fight assault charge in court. So he will contest. I've just lost my screen. He will contest the hearing. My second screen's just dropped. The hearing, I'm going to have to try and find it. Oh, there we go. Will contest the charge. He assaulted a news camera operator and damaged equipment. So he was not required. Well, usually the small ones, they don't. I mean, we'll talk about sentencing, but I'm only going to talk about the Victorian sentencing and stuff because I find my way around the Victorian stuff a little bit easier than New South Wales stuff, only because that's what I know. So he was not required to appear, so he sent his lawyer. When his lawyer entered the plea of not guilty, we're not lying down on this one. And then it talks about footage circulated appears to show the pair struggling as they grab and push one another, or the man tries to film Barilaro, who then walks away. He confirmed the incident, saying that he was confronted in a dark outside a bar and felt harassed. I can see that there's a big light myself. All I did was push him out of my way. He was charged on assault and malicious damage. They've got until the 9th of November to serve their brief on Barilaro's lawyers. So again, as I explained in the court process, the prosecutors have to lay out everything that they've got that's going to prove their point. They've also got to state, I'm assuming that they're going to have the cameraman give evidence. They're going to use the footage, various footage that's from the cameras. They're probably going to grab some of the people that were with the cameraman or camera person as witnesses. Then once they've filed their brief, Barilaro's lawyers will do their rebuttal, will file their brief. They will list all the evidence they're going to use. They're going to list their witnesses. When it goes back to court, they then present all that evidence to the judge. This is what we've got. These are the witnesses we're going to call. And Barilaro's lawyers goes, well, we want to cross-evidence the prosecution's witnesses. We want to ask X, Y, Z. And then the prosecution goes, well, we want to cross-examine Barilaro's. And then the judge is going to go, okay, how long is this going to take? How long do you need? Oh, we need about an hour each. Okay, we're going to put it down for a 3-hour hearing or whatever. That's essentially what the next appearance will do. But, and then this article goes on about he's been engulfed in scandal since 2020 after taking defamation action against provocative entertainer Jordan Shanks, better known by his nom de plume from the Geordies. Okay, so there's that one. Then there was news.com.au. Here is his lawyer. Talking. After the ad.
Hello, mate. You ready to play?
Sure, no.
I'm old, man. Let's see what you got.
That's what's his, oh, that's Max Dawn.
Oh no.
Can't think
That
of
was
his
just
name.
practice, wasn't it? Oh, too early. Top left corner. Golden point. I don't miss twice. Yes, that's how.
That's Max Gawn from AFL, and it's a rugby player. It's not. Can't think of what's his name. Oh, I should know it because he's like very famous.
It's done. I'll let you have it, old man.
Nintendo Switch. Play, connect.
It'll come to me later on. All right. Here's his lawyer.
Mr. E, can we ask you some questions, if that's all right? We're just wondering, is Mr. Barilaro still going to fight these charges?
Definitely fight these charges.
Yep, okay. And how's he doing?
Mentally, he's not well at all.
Is he well enough to appear at that parliamentary inquiry? Because I know they've been asking for him as well.
I don't know.
Oh! Now, did you hear that? He's mentally not well at all. Oops.
Anything about the parliamentary inquiry, not instructing those matters.
No, it's not. No, it's not him.
Is he well enough to appear at that parliamentary inquiry? Because I know they've been asking for him as well.
I don't know anything about the parliamentary inquiry, not instructing those.
But on the criminal matters, definitely fighting it. That's still not.
We're definitely fighting those charges.
And will he be coming to court on the 12th?
He's not required to come to court. We'll see.
What happened today, Mr. E? Because there's some evidence that police have gathered from both Channel 7 and from the radio station. But you're concerned that it was gathered not in compliance with the law.
My concern was simply a subpoena that was issued was improperly issued in the circumstances of the legislation. And my application was simply that subpoena should be struck out for any advice.
Yeah, so that's right. There was some questions over the way the subpoena was issued, and he's trying to get the evidence struck out, which means that's essentially the whole prosecution's matter gone. So he entered 2 pleas of not guilty. But it's really interesting because they brought up the apparently he's not very well mentally. All right, so apparently he's stating he was being harassed at the time. What was the other one that I had here? All right, so this is what the law enforcement needs to deal with when they're looking at crime. So we're looking at assault and we're looking at malicious damage. This is the New South Wales Crimes Act. So as I said, this is from 1900. It's been updated. It was updated as at the 21st of September 2022. There's lots of stuff that's come out. Definitions have been updated over time. So it tells you what the act is, what the definitions are, the jurisdiction, offences against the sovereign. Most of those have been repealed because except as to the offence against the person of the sovereign. So, and that would only ever occur if the sovereign was to come to Australia, because, you know. All right, then you get to the offence against the person, which we're heading to, and it starts off with the big one. Whoops. I did that well. I don't know what's happening with my computer. I'm pressing stuff. It's not working. I'm really showing professionalism here, aren't I? That's the Victorian Crimes Act. Where did the New South Wales Crimes Act go? Yeah, look, it's very interesting it's very interesting. Mental health is actually a defence that they're actually really trying to tighten up because everybody's trying to use it. Okay, so here we go. So we've got conspiracy, we've got attempts, acts causing danger to life or bodily harm. This is where we get into it. So, right. So that's all the other one. There's stuff like setting a trap, throwing rocks and other objects at vehicles and vessels. Well, that's been repealed. Dangerous driving, offence of failing to stop, etc., etc., etc. Making explosives with the intent to injure. We get to assaults. Now, the one that I've come up with, the one that he could be charged with, is 59. And I'm telling you, I find the Victorian one a lot easier. So this says, whoever assaults any person and thereby occasions actual bodily harm shall be liable to 5 years imprisonment. A person is found guilty of an offence under this subsection if the person commits an offence under subsection 1, which is this, in the company of another person or persons. A person convicted of an offence under this subsection is liable to imprisonment for 7 years. So, in the company of another person. Interesting. Okay. So, then we get into assaults at school. Common assault. I don't think it can be common assault because that's an indictable offence. I don't think it's an indictable offence because it's only a small thing. So then you get into all the other yucky offences down here. And again, some of these have obviously been updated. So there's kidnapping, voyeurism, recording, distributing intimate images. Then we've got unlawful gambling. Then we get to the stealing charges, larceny, offences relating to motor vehicle, embezzlement, receivers, fraud, cheating. I wrote down where we have to go. I've gone too far. It's supposed to be 56, was it? Oh, yeah. Sorry, I went down and wrote all of this down. Yeah. So then we get to that was assaults. Or 61. Hang on. No, 195. Sorry, I can't read my own writing. So we get down here and we get down to identity offences, money laundering, cheating at gambling, criminal destruction and damage. We get to here destroying or damaging property. So what is the definition of property? It's all here. Property includes every description of real and personal property, money, valuable security, debts, legacies, and all deeds and instruments relating to or evidencing the title or right to any property. So essentially anything that somebody owns. So we get to here, and that is a person who intentionally or recklessly destroys or damages property belonging to another or to that person and another is liable to A, 5 years imprisonment, or if the destruction or damage is caused by means of fire or explosives, 10 years. A person who in the company of another person intentionally reckless is 6 years. And if it was a public disorder. Now, interesting, Vedandra, you said, is sleepwalking a defence? This goes back to Federation. So we've got blackmail and forgery. We do have defences in here. Perjury, miscellaneous, criminal responsibility. So you've got proof of lawful authority or excuse and exceptions. Self-defence could be one. And then so it says you've got to self-defence, then what you've got to prove, what you have to prove for self-defence, excessive force. So they are actually your lawful excuses, okay? So self-defence. He's probably going to say self-defence. Hello, Totally Jade. Oh, he had to face court today for destroying the cameraman's camera. And he pleaded not guilty. So then you've got intoxication. Then you've got your sentences. Now, when we got down here, these miscellaneous offences, there was... we're going to get to stealing plants in gardens, for example, can be one. Taking fish in waters of private property. There was one down here. So these are some of the ones down here that have been repealed. So Here, abolition of the offence of being a common night walker has been abolished. Abolition of offence of eavesdropping and being a common scold has been abolished. The common offence of being a common night walker is abolished. This section does not apply to the offence committed before the date of assent to the Crimes Common Night Walkers Amendment Act 1993. So there you go. No, it's for Barilaro. So Barilaro was charged with assault and malicious damage. So we're just looking at the. So then what was this one? Abolishment. Eavesdropping. How many the common law offences of eavesdropping and being a common scold are abolished? So they abolished that. So that was nice of them. The abolishment of imprisonment with light or hard labour has been abolished. What was another one that was here? Abolition of the rule that husband and wife cannot be guilty of conspiracy. So anyway, so that's the New South Wales Crimes Act. So we get to Victoria. Victoria's is 1958. We go back to 1958. So we've had, as I said, there are some very interesting. I was going through. So this is the Victorian Crime Act. This is the one that I've been looking at. So offence to a person, and Victoria's put all the offences that you can have towards a person. Is the first one. He had a fish in his pocket while sleepwalking and bumped into the camera while being too close while eavesdropping, of course. And then we've got piracy and we've got theft here. So all the theft offences, identity crime, money laundering, criminal damage to property. So this is, as I said, this is Victoria's one. There's one that's really interesting in here that I was really shocked at, because Victoria is known as being rather progressive with our rules. So these are defences that own Victoria: self-defence, duress. Intoxication is now being used very, very, very rarely. But there's a little one down here, and I'm gonna make it bigger so that you can see it. So we're gonna scroll down here. Okay. So duress can be a defence. So down here, criminal liability of married persons. This is the one that was very shocking and surprising. So look at this one. Any presumption that an offence committed by a wife in the presence of her husband is committed under his coercion is hereby abolished. Where a woman is charged with an offence other than treason or murder, that woman shall have a complete defence to such charge if her action or inaction, as the case may be, was due to coercion by a man to whom she was married. For the purposes of this section, coercion means pressure, whether in the form of threats or other form, sufficient to cause a woman of ordinary good character and normal firmness of mind, placed in the circumstances in which the woman was placed, to conduct herself in the manner charged, whilst limiting the generality of the expression, the circumstances in which the woman was placed, in subsection 3. Such circumstances shall include the degree of dependence, whether economic or otherwise, of the woman on her husband. The accused shall bear the burden of adducing evidence that she conducted herself in the manner charged because she was coerced by her husband. But if such evidence has been adduced, the prosecution shall bear the burden of proving. It's a very interesting. I just don't have a husband. It keeps taking me away. Oh, I don't know what it keeps doing to me. It keeps it just keeps jumping all over the place. And I'll tell you what's wrong with that. I mean, if you haven't already worked out, This would be one that Katie Joy talks about the patriarchy. This is a patriarchy, very much. So it's saying that unless it's murder, a woman who would, I can always buy one. Oh dear. Anyway, let's get back to this. All right, so there it says, so then the prosecution shall bear the burden of proof, proving that the action or inaction charged was not due to coercion by the husband. This section shall operate in substitution for the common law as to any presumption of defence of marital coercion. This section shall not affect the law relating to defence of duress. So essentially, there's lots wrong with this law. First of all, you have to be married, and it has to be a wife that's coerced by the husband. So as I said, Victoria is known as being very progressive. They've gone through and they've changed a lot of the laws to include particularly with the general sexual identities of people now, and all of that sort of stuff, and the fact that there's same-sex marriage. But this law, this rule has not been updated. But it says you have to be married. You have to be a married woman who is normally of good character, that wouldn't have done anything unless you were coerced by your husband, and there has to be independence on your husband. No, Terry C., this is a law that is still current in the state that I live. It is one of those laws. It is still a current law. It's absolutely flawed. We did this in our criminal law thing, and we were asked about it, and we went, this can't be right. With your strict laws, should either be. Well, she could say she was coerced. Yeah. So then down here is pleading procedures. So, for example, pleading procedure proof. So proof of marriage on trial of bigamy, meaning of the term official record, all of this stuff. It talks about records of juveniles, how they're supposed to be done, how fingerprints are supposed to be taken, taking intimate samples. We can only abide by current law. Bella, you are right. That was absolutely shocking. I mean, if they weren't, I don't really want to go through the SA laws, but even for R, they've really changed the wording of that to include and to be very neutral in its language. But that rule still applies anyway. So then we've got here what happens if the person's convicted. So this is all what the police have to do. And then there's transitional provisions. So then you've got the Crimes Amendment Act, you've got justice legislation, you've got the Money Laundering Act, there's the Drug Act, all of that sort of stuff. So then what happens is you go to trial, you go to court, and you are ranked by a penalty scale. So in Victoria, so now I've stopped talking about New South Wales. I'm talking about Victoria, which I know. Okay, so the heaviest sentence. So everything they'll talk about levels. So they'll say this is a level 3 or level 4 offence. And so a level 3 offence. So we go to the Sentencing Act of 1991 in section 109. And we see a level 1 crime is life imprisonment. And a level 9 crime is 6 months in prison. Okay. Now, the Magistrates Court, which is the local court, it's going up, only deals with crimes up to level 6. So they only deal with up to level 6, which is 5 years. Okay. Yeah. As much as we disagree with some law, nobody can escape penalty. That's correct. I've made it big for you, Vedandra. It just went really big. Okay. So this is the Sentencing Act. So then, so they may not say, they may go, well, we're not going to put you in jail, but we're going to fine you. And so then again, then we get to penalty units. So we've got 1 penalty unit, 5 penalty units, 10 penalty units. So a level 1 crime says maximum fine. I don't know what that is. A level 2 crime is 3,000 penalty units. So then you go, well, what's a penalty unit? Well, I've had to do lots of digging here. So penalty units. This is the big rabbit hole. So, for example, penalty units are used to define the amount payable for fines for many offences. So, for example, the fine for selling tobacco to somebody under 18, okay, is 4 penalty units. 1 penalty unit is currently $184.92. So if you sold a packet of cigarettes to somebody who was under 18, you would expect to get a fine of $739.68 Australian. So that's 1 penalty unit. So I'm going to just write that down, 184.92. So when we get to 3,000 penalty units, 3,000 by 184.93, you're looking at $554,000. That's a lot of money. All right. So then that one, yeah. So then we get to, oops, no, that wasn't, yeah. So here's an example. This is from the Sentencing Council of Victoria. So life imprisonment is a level 1 and there's no fine. A level 2 will get you 25 years and 3,000 penalty units. So what did we say? That was about $550,000 or something like that. A level, okay, and I'm not going to read out what the crimes are. You can see what they are. Level 3, 20 years. So that's like intentionally causing injury and culpable driving. Level 4, 15 years. And so some examples are handling stolen goods, reckless causing injury. That's 15 years, 1,800 penalty units. Level 5 is 10 years. So that's theft, negligent causing serious injury. That would be Josh Duggar range there, 10 years. Level 6, recklessly causing injury, 600 penalty units. Level 7, going equipped to steal, is 2 years in prison. Level 8 is at cultivation of a narcotic plant. Oh, okay, plan to create. So you're probably more up with this than, I mean, I was saying how hard it is for law enforcement to get your head around these. These are cultivation of a narcotic plant, not for the purposes of trafficking. Possession of a drug dependence, not for the purpose of trafficking, is 1 year. And concealing the birth of a child is 6 months in prison or 60 penalty units. Just an example. So the Magistrates Court, which is the lower level court, the maximum that they can do is 2 years imprisonment for a single offence or 5 years for multiple offences. Okay? Where an individual or corporation has been convicted in a magistrate's court, they can be fined up to 92,000 or 462,000. So anything above that goes to a higher court. So if you, level 7, yeah. So anything that's less than up to 5 years can be heard in a magistrate's court. Once we get over that, it's got to be heard in a higher court. So I hope this has all been helpful for you. We're just trying to find out if Buzz is found guilty, I reckon he'll get community order and a fine myself. So yeah, sorry, but what is? Well, that's true. There are other things that they have to. There is a whole pile of other stuff that they have to actually take into account. I mean, this is in an ideal world, and we don't live in an ideal world, because people are out on bail that shouldn't get out on bail, and there's all this sort of stuff. Going to quit was one of the charges in my practice at the academy. Cool. Oh dear. If my penalty if I ran over a weed in my license back in wow. My penalty if I run over a weed when my license back is prison. Serves my most one. Yeah. So anyway, that is because the Sentencing Act is the guide for the again, this is the Victorian Sentencing Act 1991, but it talks about the factors in determining a character's. See, court does not have regard to previous good character or lack of previous findings of guilt or convictions in certain circumstances. So there are some things that they don't care about history. Won't even stay. Money from Google won't even stay warm. No, they won't. This is the one that's really interesting. Again, this is Victoria, that they can, if they plead guilty, and this is why they've done this, they can impose a less severe sentence than it would have imposed if the offender pleaded guilty to the offence. And the sentence imposed on the offender includes an order under. So they can actually, and often they will reduce the sentence. If you plead guilty from the outset, you will see it. It says here, if the court makes a statement under this section, it must be recorded. And you'll often see that under Section 6AAA of the Sentencing Act, because you pleaded guilty, I've reduced your sentence. Yeah. And then also talks about how non-parole periods are supposed to be calculated. They won't seize your car though. It talks about pre-sentencing reports, how it's all supposed to, victim impact statements, custodial orders, how to sentence juveniles. It's all there. It is messed up, Bella. I mean, it is totally and utterly messed up. So calculation of period of imprisonment or unpaid community work. So they have to go through this. A term for which a person, 1 day is for each penalty unit. So it's all there. Sentencing, other orders, what happens if they break the orders. There's stuff in here for what happens, the procedure that they have to follow if they breach it, what they can and can't do, how to deal with mentally ill offenders, if there's been an error made. There's these historic offences, miscellaneous, the penalty scale. So there's a whole lot of stuff in there. I mean, then you've got the Evidence Act about collecting evidence, and I know that Barilaro's lawyers talked about these questions over how the subpoenas were issued. That may actually get him off. I don't know. Not really sure about how any of that works. But that's our crimes. Well, that's the Crimes Act. So that sort of gives you. I spend most of my criminal law classes are spent in the Crimes Act. In fact, the majority of them, the Crimes Act. And then there's a Criminal Procedure Act, but that's where you spend most of your time, because you actually have to look at the offence, what court it can be done in, is there a burden of proof, what's the burden of proof, all of that sort of stuff. So, all right. My lounge room set up. Oh, no, it's just a background. I wish it was my lounge room. I'm actually in my bedroom. I mean, we haven't even got to the federal laws yet. Because we're going back to New South Wales. I know we're all over the shop, but this caught my eye, because John Barilaro was the former Deputy Premier of New South Wales. Well, the current Deputy Premier of New South Wales has got some trouble now. It seems to be going with the job. Police Minister Paul Toole's brother, Joshua, arrested in a Newcastle drug bust. Now, it's his brother. But not only is he the Deputy Premier of New South Wales, he's the Police Minister. So Paul Paul Toole is currently the Deputy Premier of New South Wales. He is the person that replaced Barilaro. He's the National Party leader. He's the National Party leader. Joey's going to sing it. Yeah, funny. So he is essentially the new Barilaro. That's the only way I can describe it, simply. The brother of Police Minister Paul Toole has been arrested in Newcastle over his alleged involvement in a large drug supply syndicate. Now, remember, with both Barilaro and Paul Toole's brother, they're alleged. You're innocent until proven guilty. So they're both allegations. Not saying they're guilty, okay? So it's alleged. Joshua Toole, 38, was among a group of 4 arrested on Wednesday following a 6-month investigation into the supply of meth. We're not talking about little stuff here, by the Drugs and Firearms Squad. I'd say that this is going to be come under federal. I think this is going to be a federal law thing. The Daily Telegraph understands Joshua is currently being held at Belmont Police Station and is expected to be charged later tonight. He's likely to spend the night in custody before facing court tomorrow. No bail for you. Well, actually, yeah, there's elements that we have. I think my last video I went through the bail requirements. He might do, but it is a very serious charge. Paul told the Telegraph on Wednesday night he was devastated by the news. I am devastated, but we are not the first family to have to deal with this, and unfortunately, we won't be the last, he said. No one is above the law. It'll be interesting to see what happens now because he's the police minister and this comes under his portfolio. Whether he, it'll be interesting to see whether he goes hands off. Anyway, Joshua and a 24-year-old woman was arrested in a vehicle stop in Canary Vale at 9 a.m. by officers attached to Strike Force Great. Investigators then carried out search warrants in Belmont North, Nords Wharf, and Wabulda, locating and seizing methamphetamine, approximately $150,000 cash, electronic devices, and other items relevant to the investigation. Around the same time, a 43-year-old man was arrested in his Belmont home and a 42-year-old man arrested at his workplace in Wyong. They have been taken to Belmont Police Station and Wyong Police Station, respectively. So, that's a big lot of, big wad of, yeah, Keller said the WA, I know, they still want to try and traffic drugs into the country. I can't believe what I'm hearing. It just proves that I don't watch that much TV and I only watch it. Well, I don't watch, that's just come out today. All of this stuff's just come out today. In the last, I think it's Wednesday today, isn't it? So, yeah, I don't watch a lot of it. And I found it very interesting that there wasn't a lot of news on it because it's only been in the last couple of hours. It's been very hard to find stories on it. In fact, there's only three Sydney Morning Herald, the Daily Tally, and 9 News are the only 3 that have covered it. Everybody else is not touching it with a 5-foot pole, which is wrong, in my opinion. But I'm assuming that's going to come under I think there's a Drugs Act. I'm going to have to do more searching for that, but I really just wanted to talk about Barilaro and talk about the Crimes Act and the Sentencing Acts and all of that sort of stuff. So, yeah. Look, the world's messed up at the moment. I mean, and then you've got the they keep calling it the Brittany Higgins trial, but it's not her trial. She's not on trial. She's the victim. The perpetrator, the alleged perpetrator's name doesn't get mentioned in all, but they all focus on the fact that Brittany Higgins is the one that was AR'd, and they're calling it her trial. She's not the one on trial, but they're making it all about her and making it like she is the one that's done the problem. And then in Victoria, you've got the legal advisor for the current opposition leader standing down. They've had all their senior staff resign over the last few months. There's an election next month. Hardly anybody's going to be around. Yeah, so anyway, I don't know what else to say. Oh, and apparently Tom Mitchell, by the way, for those of you that follow AFL, Tom Mitchell is now Magpie, by the way, for those of you that are interested. There you go, Bella. You're a Collingwood supporter. You've got Tom Mitchell going to play for you in 2023. That's all I really wanted to say. I just want to really thank you all for your support. And, as I said, I'm doing really good at the moment. Life is great. And I'm studying. How's this for a mouthful? I've got to actually look at law and policy of misleading conduct and product liability. Law and policy of misleading conduct and product liability. We've got to look at the Australian Consumer Law and the Defamation Act. They're the two. It's essentially when you mislead people over the product that you're selling. My next exam is Monday, and then I've got my last one on Thursday. And then I'm working at the horse racing. I'm working at the Cox Plate. So we get into the spring. We're getting into the spring carnival. So that's pretty exciting. So misleading, because companies and businesses that have over 10 employees. I know, Terry, it's absolutely disgusting. It is really terrible. And in fact, she couldn't appear the second day of evidence because the stress was too much, because his defense team was trying to imply that she was drunk. She had to admit that she was drunk. And that she wore the wrong type of clothing, which we know that is absolutely disgusting. Okay, on a side note, you can write down the name of the shop and the name of the kit somewhere in the corner of the Playing With Me page if you want to remember. Okay, I'll try and remember. I try to remember, but this week's was another one I just slapped together. I don't have a lot of kits at the moment, Vidandra. I've got to go shopping. In fact, I just got paid. I'm going to go and look at Plan to Create shop shortly, because she's pretty good with her postage time and with her postage. But I'm down to having to make up my own little bits and pieces and using scraps again. But I think I've got one to use tomorrow. I have a couple of Christmas ones, though, cool Christmas ones. That you can't see them. But I've got a couple of good ones for Christmas that are coming up. Yes, totally jaded. There are people that are absolutely defending her left, right, and centre. Yeah, there are. People are appalled, actually. In fact, it says. In fact, I'm just having a look now. She apparently is coming back on Friday. Brittany Higgins will return to court to complete her evidence in the trial of Bruce Lehman on Friday. So that's good. So the trial had to continue because she just couldn't face. The trial raises pressing questions about how SA is handled in Australian courts. Our practice of cross-examination for such cases is archaic and shameless. So, and there's also been a non-publication order as well. So it's really hard for people they can't publish a lot of what goes on. But she was unavailable for cross-examination. So she's been unavailable for a few days. They just said that it just took it so much out of her. She spent 3 days being cross-examined. There were 58 witnesses listed over 6 weeks. Secret recordings, clashes over deleted text messages and claims. So it was interesting because there was some text messages that she deleted, and they were saying that it was she deleted messages and photos before handing it to police, and she was accused about lying about a doctor's appointment to bolster her claims. So she's been essentially accused as a liar, and apparently she'd agreed to a book deal, and that means that she was after blood, and yeah, it's really, really messy, and it's really, really messy. But she's been made out to be the one on trial, not him, which is absolutely disgusting because she's the victim. But I'm glad she's coming back. But there is a jury, and the jury has and it's a female judge. I don't know about the jury, but they had to approve to that. So yeah, so it's just very archaic. See, we can't report many details right now due to a non-publication order, but Brittany Higgins is due to resume cross-examination soon. At the moment, she's unavailable to give evidence. But yeah, so it's all about, they're saying it's archaic and shameless. So it's good that she's returning to fate, to the thing is they have to prove him. I don't know. He's been charged with sexual intercourse without consent. Love you. All right, see ya, Cal. Yeah. But anyway, that's six weeks of trial. But yeah. Anyway, that's one that's really, and I've really stayed away from that. But yeah, that's just a real big summary. But as I said, I'm glad she's coming back to coming back to face him. But look, she's been Australian of the Year, and she's really become a really big advocate for women's rights and stuff. So that's good. Anyway, based on that, now on that note, I will catch you next time. It might be tomorrow night. We'll have to just see how life turns out. At the moment, I am just head down and study my little backside off for the exams. Tomorrow's Thursday, so I work on Friday, and then I think I'll get the weekend free. Oh no, I'm in Geelong on the weekend. Oh, see, I'm just so busy. I don't know where I am. But anyway, I want to thank you for joining me. As I said, there are ways to support the channel down below, just down here. Thank you very much, everybody. And I will catch you again, maybe tomorrow night. Who knows? You just never know when I'm going to pop up on your screen. Thank you for all of your support. Bye for now.